Welcome back to the Legal Paige podcast. Today we're going to do something a little different. Never done this before, but I'm going to do a rapid fire legal Q&A straight from our Facebook group. So I'm going to give you quick, practical answers to legal issues that entrepreneurs like you are facing right now. Whether you're dealing with contract issues, trademark, intellectual property, copyright issues, or client disputes or client communication errors back and forth, I have got you covered. I'm going to give you straightforward advice to help you navigate this as a business owner. So what I'm going to do is straight up tell you, hey, this is what this person asked in the Facebook group. Here's my candid legal answer to this. It's going to be fun. It's going to be different, and it's going to be quick. Let's get into it. Hey there, I'm Paige Griffith, your host and an attorney for small business owners. I help online businesses and creatives get legally legit in no time. This podcast is all about the legal and the Paige behind it. I'll break down and simplify legal talk while providing practical business guidance every step of the way. And after over a decade in the entrepreneur space and becoming a mother, I'll also be sprinkling in tips for running a business and giving you a glimpse behind the scenes of what life's really like. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney. So be sure to seek legal counsel for personalized advice. Welcome to the Legal Paige podcast. All right, so like I mentioned, we came up with this idea, my podcast manager and I, to just do random episodes every now and then, maybe every month, maybe every couple of months on, hey, this is what's going on in our Facebook group. And this is my answer to this question if I was your legal counsel. So before we get going, let me just straight up tell you what the Facebook group is. So it's called the Legal Paige Community on Facebook. And anyone can join if you're a business owner. You just type into Facebook, the Legal Paige Community. The group will pop up. There's thousands of business owners in it. I think over 9,000 now, or we're getting really close to 9 or 10,000. And myself and my legal team monitor this group. So you just answer a couple questions, you get into the group, and then you can start seeing what people are getting asked, what questions they have as a business owner, like how to best wear their chief legal officer hat. And then myself and all of the lawyers here at the Legal Paige, we go in and we answer these questions. So it's in a group environment. So I can basically kind of be your one-on-one attorney, but everyone else gets the answer to the question as well. So it's a really good group exercise. And it's a fun place as well. If you don't even have questions that you want to ask as a business owner, you can go social listen and see what everyone else is up to and spark your curiosity, and maybe something will change in the back end of your business on how you send that client contract, or what you would do in a similar situation with a client, or why is that clause even in my contract? And I answer as to why it is. And then you're like, I'm enlightened. Sounds good. All right. So let's get into this. My one ask from you is if you like this type of episode, this Q&A rapid fire from me to you, let me know. Because if this is a hit, I'm going to keep doing it. And my team will grab a bunch of questions from Instagram, from Facebook, from YouTube, maybe even, and I'll just always do some random legal Q&A episodes. Okay? That's what I ask of you. So send me an Instagram DM or write a podcast review on this episode. That would mean a lot to me, so I can hear that with thumbs up, you like it. All right, let's get into this. So the first question comes from Sydney, and she says, I have a question on Clickwrap agreements where you check yes to agree to the terms. How is this enforced? Who provides the terms to the court if it needed to be enforced in court? She says, couldn't one of the parties produce an altered set of terms at the time of a disagreement? To my knowledge, the softwares that I'm using for Clickwrap agreements aren't recording a copy of what you actually agreed to at the time, and usually the terms are liable to change or be updated. So just wondering if this method is still good to send contracts and have people sign, or should I use DocuSign? Okay, so my first answer to this is Clickwrap agreements are totally fine to use as long as the software that you have is sending them the terms that they agreed to at that time. And if your software isn't, then you need to at least download a PDF of that agreement that was signed on, say, August 25th and what those terms were. That's really important that they're getting a set of that. If they're not, and Sydney's saying I don't think my software is doing that, then yeah, you're probably in a predicament. And ultimately, Clickwrap agreements oftentimes are at the discretion of the business that may update them, but you are liable for notifying any customers or clients that have signed a Clickwrap agreement to the updated terms. So they need to get a copy of the terms that they signed when they agreed to XYZ with you. And you have to legally notify them of any updated terms and then send them a copy of that. We've all experienced this online where we sign Clickwrap agreements for anything, like, I don't know, Google Admin Suite. And then terms are changing for Google Admin Suite, and we get notified from Google, here are the updated terms, link here. As long as you're notifying them and they move forward with like paying for Google Admin Suite, then they have essentially agreed voluntarily to these new terms by continuing on. So it's kind of an implied set of agreement to legal terms. So Clickwrap agreements are fine. I don't love Clickwrap agreements for like one-on-one client situations, bigger, more risky liability that you may have as a business owner. I definitely suggest that you use DocuSign or an online contract sending platform of your choice for that purpose so that you're actually getting a signature from your client. Clickwrap agreements are usually good for broad subscription memberships, group coaching situations, online courses, those types of things is what I suggest you use Clickwrap agreements for. One-on-one client stuff, I do always suggest that you use an actual contract signing platform. Okay, next up, question about possibly merging contracts. This is from someone anonymous. I have a graphic designer contract and a website design contract, but I do both for my clients, and I'd love to just be able to send one to my clients when they hire me for both graphic design and website design. So is it possible to do this, or is it not recommended since sometimes they're different services? All right, definitely possible. What I always suggest, though, is you just make sure that you're not missing any important clauses from each contract. So look at both contracts and decipher, okay, these are the must-have clauses for graphic design. These are the must-have clauses for website design. And then you may want to have strong headings for graphic design with subheadings for all of the clauses underneath that, and same for website design. So it's really organized in this bigger contract that you're going to send to clients. So if they have a question about graphic design deliverables, they know exactly where to go in your contract, and same for website design contracts. And then you just don't want to mess up the miscellaneous provisions that need to be in that type of contract. So those are going to be the same throughout. So those are going to be similar in each contract. You're going to see at the bottom the boilerplate provisions for entire agreement and force majeure and indemnification and severability and transfer and venue and jurisdiction and counterparts and facsimile signatures. Those you just want one clause of each in that combined contract. But if you are nervous about combining contracts yourself, I do always suggest that you get an attorney to help you with merging so that you don't miss anything. But we get this question a lot about various different offerings that people could have. Hey, I do this and this. Can't I just put it in one contract? The answer is always yes. It's just, can you manipulate your legal language yourself in your contracts, or do you need a lawyer to assist you? So that's my answer there. The next one is from Austin. He says, quick question. I had a couple sign a contract and then followed them on IG. So he followed them on Instagram a few days later. And I found out that the groom's legal name was different. And he says, I don't know why they would give him his nickname for a contract, but should I have them sign a cancellation agreement and then send a new contract with the correct names? What's the most efficient way to go about this? Okay, so the first question that I have here is like, how far off is the nickname? For instance, I wouldn't worry about it if it's Will for William. And then Austin replied, they call him Jack, but his name is John. So it's actually, it's okay. Legal names are preference, but courts will honor nicknames if they're widely used. And if there is an intent to be binding to the contract, then you will be fine. So it's a good time to kind of create a little reminder to future clients regarding signing with their full legal name here. But it's good to know, legally speaking, that nicknames are fine to sign as. as long as that you have an intent to be bound to the contract from all parties. So there's a mutual intent to contract there, and that you can actually put on paper or have evidence of that this is the nickname of this person, but this is their full name and this is the same person. That's the main issue that you would be facing here is this the actual person that was supposed to be signing this contract? And that wasn't an issue here. So it's okay. You have an intent to contract. You have implied consent here, even if it wasn't their legal name. But a good tip and a good reminder for everyone listening in is to definitely use the term legal name instead of just name. So what is your full legal name that I can make sure that I add to this contract for signature purposes? You can always change out your lingo from learning experiences like that, so you don't get into a situation when you're like, ooh, was that the person who was supposed to be signing this contract? All right, next question. Debbie asks, legal and privacy. With an online business, what aspects do I need to do to comply with legal and privacy? And how should this be set up on my website? So I always suggest that you have a website terms and conditions and privacy policy for your website. Website terms and conditions are all about the users using your website. So any copy, imagery, design aspects, intellectual property of your website that's owned by you, you want to disclose and notify people that they can't infringe on that intellectual property that you have for your website. A privacy policy is all about the who, what, when, where, why of acquiring someone's personal information on your website. That can be just their first name and their email. If you have a pop-up, then you're legally required to have a privacy policy on your website on what you're going to do with their name and email and how it's going to be used and what happens if you get hacked or any third parties that you may be sending those emails to, which you shouldn't do unless you disclose that you're going to do that. And then a privacy policy is obviously also required if you're getting anyone's credit card information and banking information from your website. So checkout purposes. If you are having something that's being sold digitally, or I definitely suggest that you get a either digital product purchase and use agreement on your website or just a product purchase and use agreement. And that's the little checkbox going back to Clickwrap agreements. That's the one that they are agreeing to before they hit submit or purchase on your website. And then finally, I always tell people, okay, if you're worried about the legal and privacy aspects of starting a business, definitely suggest filing as a limited liability company, an LLC, at the beginning stages of your business because it protects your personal assets while starting a business. So then you separate your personal assets from the risks and liabilities that you will have now within your business. It's like creating two separate bubbles for your business. One will deal with the business aspect. One will deal with the business risks and liabilities, and everything involved in kind of your business bubble stays within that business bank account. And they can't kind of what's called pierce the corporate veil and get access to your personal assets unless there's some type of intentional act there. So it's limited liability on you as the owner, which is why an LLC is awesome. I like to think of it as the best insurance that you can get for your business. Okay, next question. Hey everyone, this is from Madison, wondering if anyone has questions for managing clients who aren't following their payment schedules listed on the contract and aren't communicating about it. She then goes on to say, I am flexible with payment schedules, and I always note that when going through the proposals that I can adjust from my norm. However, I have a client that has ignored all of my payment reminders, automated, and the ones that I've actually manually sent. They were communicating yesterday regarding site visits and responded to those questions, but ignored the payment reminders. I don't charge late fees as they are a day of planning client. Okay, so now I'm getting to this is a wedding planner, and I require payment 30 days out. So I haven't done much in the way of time invested, but I'd like to avoid firing them until their final payment is late. Thanks in advance for any advice. Okay, so the first thing I always suggest for people, this is mainly just a business question, but legally speaking, let's go to your fee and retainer section of your contract. That should be like the first clause in your contract. And I actually do suggest that you have a late payment subclause within that clause. We call it just like a paragraph in that fee and retainer clause. And it should inform clients that they will get charged late fees. And you actually have to move forward with enforcing those late fees, because otherwise you're not incentivizing them to pay. So while she says, I don't charge late fees, I'm like, but you should. If you're worried about them not sticking to the payment schedule, they have no incentive right now to stick to the payment schedule because you haven't charged them late fees. If they're going to get tacked on late fees, I can guarantee that they're going to look at your payment reminders a bit more thoroughly and probably be a little more proactive in paying them because they don't want to be charged more than they already are. And then last thing is you just need to set clear boundaries. You need to say, I'm not working on this. I'm not communicating with you. I mean, in a nicer, kinder way, but you need to be like, I can't do XYZ until I get paid. So while I would love to respond to your questions about site visitation, I really need you to pay your open invoices right now in order for me to move forward with the services that I need to render. I don't know. You could say that in a different way, but you have to set boundaries here. You have to enforce late fees so that they're incentivized to pay. And then you also have to enforce, I'm not going to work more without getting paid. It's really as simple as that. Okay, next question. Katie asks, I'm looking over a contract sent over to me from a client, but it mentions insurance, and I've never considered insurance as a graphic designer. So this person's a graphic designer. It mentions workers' comp and general liability insurance. Do I really need these? You only need workers' comp if you have workers in your business. If you're a solo-owned business owner, you're not legally required to have workers' compensation because you're technically dealing with any injuries that you may have on the job and compensating yourself for that. The minute that you hire out an employee, you are legally required to have workers' compensation insurance, either private or through your state government as well. Now, general liability insurance is optional for all business owners. But the reason that this contract was, I don't know who this client is, they're a graphic designer. Really, they probably just want to be sure that you're covered in instances of errors and omissions that you may have as a graphic designer, or things that may occur, that you have proper insurance to cover you and that they won't be liable for any of issues that you may face. So any like third-party infringement claims that could come up with intellectual property, say, as a graphic designer, that's the first thing that comes to my mind. In that respect, yeah, general liability insurance is a good idea. As a graphic designer, it's probably really inexpensive. You don't need high limits. You just need basically umbrella protection in case of those really situations. We're talking here just a few $100s a year for that type of insurance. So if you get quoted way more, be leery of that. That's probably too high of limits and you can lower those. So general liability insurance, yes. Well, you don't really need those and you legally aren't required to have general liability insurance. It's just always a good idea. Right now, this person is self-insuring, so it's fine to self-insure. But yeah, I always suggest get an LLC and get insurance as a business owner. Those two with the contract first, then think about the business structure. Do you want to be a sole proprietor or LLC? I always recommend LLC and then get insurance. Those three things, boom, 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 check those off. You're good to go and are going to set yourself up really well to be a legally protected business. Okay, last question that I have is from Corinna. I hope I pronounced that correctly. She says, I have a client basically wanting to rewrite a lot of my contract. We get a lot of these questions in the TLP community where they're asking about, hey, this client is redlining XYZ. What do I do? So she goes on to say, I will do another post about the rest of it, but he lives in Boston. The wedding will be in France. I have the legal page force majeure clause, and he's telling me it's wrong and giving me different wording that states he gets all monies paid, including reservation fees in the case of a force majeure event. I also have the legal page COVID-19 clause, and he's telling me that that's wrong, yada, yada, yada. Okay, so this is an amazing question. One, force majeure deals with performance. It means that one or both parties cannot perform under the contract because it's impossible to do so. And I just had an episode on this. So if you have additional questions about force majeure, just go listen to that previous podcast episode. It was a couple of weeks ago. But a force majeure clause is not like a get out of the contract scot-free clause. It's all about shifting performance. So if you can't perform under the contract, that non-performance does not equate to a breach of contract. So from about June 2020 forward, once most states and most countries had opened back up, force majeure did not apply to COVID-19 anymore because it was possible to host this, looks like it's a wedding or event. It was just kind of at a lesser capacity and modifying the overall guest list, maybe modifying the location a bit. So you're just changing performance. It wasn't completely impossible to perform. You just had to modify performance a little bit. So force majeure usually does not apply to COVID at all anymore. The only instance it would apply, and maybe, I'm saying a tough maybe here, is if there was a shutdown again. But I think that we all could say that that's potentially a foreseeable and predictable thing that could occur if the virus got really, really bad again. And now we all kind of know this since we've faced a pandemic in our lifetime. So I wouldn't say that force majeure would necessarily apply like it did in March, April, and May of 2020. A COVID clause, if they still have that in their contract, that's really your business policy surrounding COVID. And you have the right as a business owner to make your own policy surrounding COVID. So when the client is saying that your COVID-19 clause is wrong, then the client is just saying it's wrong for them. It's not beneficial to them and they want to change it. So it's more beneficial for them. And that doesn't necessarily fly with me. When clients redline contracts like this, one, it's kind of an orange flag situation. I'm like, is this the right client for you? They're messing up your contract, your business policies and practices on what you do to make it even keel across the board with all clients and setting your boundaries as a business owner as well. And they're asking you to shift those boundaries. So you need to decide, am I going to negotiate on these clauses? I probably wouldn't. And if you are going to negotiate, like how far will you go? So I always suggest to all of your clients that they get wedding insurance in case they do have to cancel if they're really worried about that for any force majeure or COVID-19 situations. Go get insurance. You can do that now, like day of wedding insurance. If you have a destination wedding, you're getting travel insurance as well. And just keep in mind while talking to your client that your contract really should not be changed to fit their preferences. Maybe you're going to meet in the middle, but your contract is in place to protect you as a business owner. And as a business, it's okay to stick to your guns a bit in these situations. All right. I feel like that was a really good way to end the episode here. That your contract is only as good as your willingness to enforce it, and your contract is only as good as your willingness to keep your business policies and practices in it and not let your clients walk all over you. Sometimes negotiation needs to be in place so that you make your clients feel comfortable, but I don't want you to be changing your entire contract to fit your clients' needs. Your contract is there for a purpose, and it's there for your business protection purposes. Hopefully that was fun for you guys to listen to a little bit of rapid fire answers from me regarding legal questions that are happening day in and day out in our Facebook group. I get them all the time on our social media channels as well as YouTube. So you can always ask me questions and I would be happy to answer them in environments like this where it's group-esque in lots of people listening to the podcast. And then hopefully you liked the episode as well on transitioning and moving out of summer to fall. I just want you guys to have a really good mindset moving forward into this busier season. If you have any tips and tricks that you would like to share on what you do that really helps you move in to fall mode and winter mode and busier work mode, please let me know. I'd be happy to share those with everyone as well. And please let me know if you have any additional questions or legal issues that have arisen in your business that you would like me to touch on more in future episodes. So that's all for now. Talk to you guys next time. Okay, that's it. That's a wrap on today's rapid fire legal Q&A. I hope these answers have given you the clarity and the confidence to tackle all of the legal challenges that you may face in your business, or at least some of them for now. If you have any more questions or need further guidance, please don't hesitate to reach out in the Legal Paige community on Facebook. I'll make sure to link it in the show notes for you. Or you can just connect with us directly. You can email shop@thelegalpage.com and we can send you over some referrals for one-on-one attorneys, or I might be able to help you with my law firm as well. So thanks so much for tuning in. If you found this episode helpful, please share it with one of your fellow business owners that you love that may benefit from listening to this. And also subscribe so that you can catch up with all of the next episodes that are to come. If you leave a review for me, that would also mean a lot on Apple Podcasts. So until next time, my friends, please, please, please keep building, growing, stay educated, and stay legally protected. Thank you so much for tuning in to today's show. Be sure to visit thelegalpage.com for contract templates, blogs, YouTube videos, and additional legal resources. If you haven't already, head over to iTunes and leave me a review and rating. It truly means so much to me to hear your feedback and inspires me to continue creating podcast content. Also, I want to personally invite you to my free Facebook group at tlpfacebook.com, where you will get access to me, my legal team, and thousands of other entrepreneurs in there for unlimited business and legal Q&A. Until next time, my friend.